Hello, everyone. I think we can start slowly. My name is Margaret, and today I will conduct this webinar for you with Kamila. And today's webinar will be slightly different because we will talk not just about GDPR and cold emails, but we will try to persuade you and show you why being a GDPR compliant company is so crucial to send GDPR compliant cold emails. So we truly believe that it's impossible to say my messages are fine without all company internal procedures. And we've done a lot towards facing those requirements. So we would like to share our know-how and how we managed to become a GDPR compliant. During whole webinar, you can use Q&A section, so feel free to ask questions anytime you prefer, and we'll try to answer some of those questions live at the end. If you don't hear your answer live, still no worries, we'll email you with explanation, so you will anyway get the answer to your question. Okay, so as a way of introduction, my name is Margaret, and here's Kamila.
Hi everyone, I'm Kamila, I'm Head of Office Management here. I have been working with Margaret to prepare our internal documentation on GDPR. So I'm here to give you more tips on how to maintain your internal GDPR documentation.
And on a daily basis, I serve as data protection officer at Woodpecker. So because of that, we usually handle questions and requests regarding GDPR procedures. That's why we wanted to share how we managed to conduct those actions and give you some tips and tricks how you can make it easier for you. Okay, so I think we can start.
Sure.
Okay. The first thing is just the schedule of our today's webinar. So what we will discuss. Firstly, we will talk about two perspectives on this one document, because as we know, some of our users, or if you are thinking about starting your journey with Woodpecker, you may be either from Europe or from any other country. So we will try to keep it not only as internal European perspective, but also give some insights, as, for example, for customers or for agencies, for SaaS companies from the United States, knowing about GDPR standards may be also important from a business perspective. And then we will try to tell you a little bit more about GDPR compliant cold emails.
Yes. After that, we'll briefly tell you about GDPR related documents you should have and how to maintain it.
Yeah, and then we will try to explain you how we manage the documentation, because that's probably the worst part to manage, in a sense that it's usually a lot of work and it takes some time to go through. So we will try to show you what is, in our opinion, of course, the minimum to face it. And as the last point, but very important for us, is how you can manage GDPR requests at Woodpecker, because we dedicated a small part of the software to be GDPR compliant. So we will try to explain you briefly how to manage.
Yes, and at the end, there will also be a Q&A section. We will answer some of your questions, so feel free to include them in the Q&A section below.
Sure. Okay, so starting with the first one. Yeah, GDPR, external and internal perspective. And why we are basically mentioning it? Because, of course, if you are from a European country, that seems to be very obvious that complying with GDPR standards is not the matter of choice, but it's a matter of necessity. So if you are inside Europe, you have to comply with GDPR standards, meaning you should have some type of documentation, internal, as we'll explain later on, terms like risk assessment and so on and so forth. But you should also include minimum information clauses in your cold emails. But then we got quite often questions from any country outside of Europe. Is it necessary for them to be GDPR compliant? And that's a tricky question, actually.
Yeah, it is. Because, of course, it depends. It depends on your business. It depends on the market you're targeting. If you run a business and you are targeting European markets, so you'll possibly be processing data of European citizens, then it is necessary for you to be GDPR compliant because it mainly concerns, as I mentioned, processing data of European citizens. If you don't do it, so if you don't target European market, if you don't send emails to Europe, there is no need for you, so you don't need to be a GDPR compliant company. However, we strongly encourage you to do so if you offer an online platform, a tool, software that enables clients to contact people from all over the world. So if there is a chance that your clients will be using your tool to send emails to Europe, we do recommend for you to be GDPR compliant to be a better choice for your clients.
Yeah, exactly. So it's it's a legal standard only within EU, because obviously it's EU legislation, but then it becomes something like a business standard outside, because if you conduct any type of business and you wish to cooperate with either European companies or simply you wish to gain, as for example, lead agency, customers from Europe, at some point, usually you will get a question like, hey, can we sign data processing agreement or addendum or anything similar? That's why we encourage you to try to get customized to those standards. As a good example with the US and Privacy Shield, because for example, companies from the United States may wish to get something like Privacy Shield certification. And the other way around, if you are from Europe, but you are wondering like if you should purchase the service or a product of a company, but you need to share the data, looking for something like a Privacy Shield certification is a good idea. Just not to get you too bored, quick explanation, what is Privacy Shield? Privacy Shield is an agreement between EU, so European Commission, and United States, which regulates, basically, which says that United States is a country safe enough to save data. So the processing looks like that's slightly different. If you want to send data to the United States, it's not like you are sending to any country which is not required of a safety standard. So, and Privacy Shield certification works like simply you send terms of service or any other documents you have to the program which can get you certification. They check if all compliance requirements are there, and then you can simply be on the list of Privacy Shield certified providers. So that's just for those of you who are either from a state or you are considering how to check if the tool or service from the United States is not GDPR compliant, but somehow similar to those standards. Okay, so this is just introductory remark for you. And now we'll try to go into GDPR compliant cold emails.
And we will try to explain to you what really does it mean to send GDPR compliant cold emails. The point we're trying to prove today is that you cannot send GDPR compliant cold emails without being a GDPR compliant company. So we have listed here 3 things that we think they are the most important when it comes to sending cold emails that are GDPR compliant. And we will quickly go through them one by one. So the first thing is minimum standards concerning information, which means that if you are sending emails to Europe, to European citizens, it means that you're processing data of those people. You need to include GDPR disclaimer at the bottom of the emails that you are sending. So this is the informational clause that you need to include in your emails. In which there should be an information about who is processing specific person's data, for which purpose, for how long, if they don't want to receive emails from you, where they can write to, and how long does it take you to process their request. When it comes to the basis of sending your emails, before you start sending those emails, please think about legal basis for that. Because if you have clients, if you have like business advisors, partners, you probably have some certain agreements signed with them. So we think that this is enough basis to, because you have business relation to exchange emails with this person. However, if you're sending cold emails, this person did not give you their prior consent. So we figured that we look at cold emails as direct marketing purposes. I mentioned also the time frame for processing the requests from your prospects, because when you include this informational duty at the bottom of your emails, and you include storage limits. So let's say that you are sending your campaign with 5 follow-ups, and it's been a month and a prospect did not reply to your 5th follow-up. So there is no more legal basis to process their data. So please watch for the fact that if you claim that you will delete their data after 30 days, if they do not reply, you need to watch that and really pay attention to doing that. 2 more little things about the disclaimer itself, because it's not like you can use font 5 and light gray. For the disclaimer, when you're using fonts 12 and color black for the content of your email. The disclaimer has to be clear and easy to find by the person that you're sending your email to. From that, they should be easily informed who's processing the data for what purpose and so on. But you don't have to do it in a long, boring way. We encourage you to keep it creative. For example, we at Woodpecker could write something, knock knock, who's there? Woodpecker, I'm just processing your data for this purpose, for that long. So, you know, keep it creative.
You know, just what we are trying to tell right now is that it's still all about business, and GDPR was not created as the aim of making this document to ruin all potential form of business which use online marketing or any type of marketing. But definitely there are some additional things you have to keep. So you need, in the message which you're sending, tell to the prospect, so to the person you're addressing, who you are, how you're processing data, and for how long, and for example, how to withdraw the consent or correct. But no matter how you will do it, it's just for your creativity. We are highly recommending you not to copy paste the very long clauses, which will be longer than your email, because from a business perspective, that's a horrible idea. And definitely your prospects will, you know, admire that they get something different than what they get usually. So there is still something to flip around and try to use in interesting way. So that's this external part, which we mentioned. But at the beginning, we said that we will try to convince you that it's not possible to be a GDPR compliant company, and then saying that it's regardless of GDPR compliant sending cold emails. Because in fact, that's one processing. So it's related to the second point you can see on the slide, internal data processing standards. And what did it actually mean? Well, to assume that we have some standards, firstly, we need to know how we process data. And usually that's the worst part to go through, because you should, at least we recommend you, to create something like a risk assessment with data processing registrar. We decided to keep it as one document, so to avoid situation that we need to update all in two places, but it's up to you. And now how we did it. So data processing registrar is a description of all processing of activities which we undertake on certain type of data. So let's imagine that our outbound team conducts any campaigns to target new customers, to get in touch with, I don't know, new agencies, to do any procedure which contains cold emails. Then we create such registrar for this activity. And how we do it? Firstly, we think what kind of data they will use. And if that's a cold email campaign, most likely they will use email address, because that's necessary condition. Then probably name, maybe name of a company, maybe, I don't know, job position. Any type of data you collect, you may assume that those are personal. Personal meaning that you can identify a person by those data. So then you just describe it. So say in the first column, which is called type of data, you write email address, name, surname, job position, and so on and so forth. And then in the other, so the next column, you can write like types of activities. So for example, if we do outbound activity, usually we start with prospecting. So the person is manually choosing prospects. So that's first step, so data collection, and we may shortly describe how we do it. So for example, browsing on internet, I don't know, checking Twitter. It depends how you manage it. Then the second is what we do when we get those data. So usually when we get prospect, we start either directly at Woodpecker and then we add customization there, or we create an Excel CSV file and then we add snippets and so on. So that's organization. So we internally organize those data which we collected just a few minutes ago, and then we upload it to Woodpecker. So that's basically the short scheme of how we do, very briefly, of course, outbound activities concerning data. So this is a registrar, the brief description of a sequence which you repeat each time you want to send a cold email campaign. And then it's a risk assessment. That's more difficult part, but still doable. So in this part, you need to assess what is average risk if those data get revealed somehow. And of course, it sounds abstract, because that's difficult right now to assess what may happen if someone gets my email address, because it depends, what do I have connected to this email address, and so on and so forth. But try to generalize as much as you can. So, for example, it's difficult to imagine that there will be physical harm because someone gets my email address. Or it's very difficult to take a loan on me just because someone gets my email address. So you try to, for example, include an information. Physical harm, barely possible. Financial harm, barely possible, and so on and so forth. But then, for example, emails leakage, possible. And what's the level? High, low, medium? It's up to you. There is no one scheme which will be always adequate and always good. But even if it's not, 100% done in the best way possible, it's still better to have it, because if it happens that you are in a EU country and you get any administrative control, and there is someone coming to your office and asking you how you process data, and then you start with saying like, yes, so I'll explain to you, you'll have just your explanations. And if you have a document, basically you have something to show. So you're always in a slightly better position. That's one plus. And the other plus is actually point 3 from the slide. So being customer and prospect friendly. So simply that usually at some point, if you are acting, for example, as a lead agency, you will get a customer who will ask you like, hey, how you process data? Or I have risk assessment to fill and I need information from you. So then you don't start from the very beginning, but you just take this information you have collected beforehand. And the same with prospect requests. So for example, someone asks you like, hey, delete my data from everywhere. And you don't start looking where is actually this everywhere, but you just take the document and follow the steps.
Yeah, so it's also important from business perspective. So to remember that people that are using your tool or your service have their own risk assessments too, and they have people who are responsible to deliver those kind of documents. If they don't, they might just resign from using your service. So that's why we are saying about that.
Yeah. So now we'll move slightly to two magical documents which we hear about often, and actually we get on daily basis requests concerning DPA and NDA.
Right. So you can see full names of those documents just below the title. So DPA stands for Data Processing Agreements, and NDA stands for Non-Disclosure Agreements. We will briefly tell you about what those documents maybe have in common, have specific to one another, why they're important. So I'll start with non-disclosure agreements because this is an agreement that can cover many different things. It basically defines confidentiality about certain subject. It may concern trademarks, intellectual property, trade secrets, but also personal data. And we're also mentioning this here because we get questions about, I don't have a data processing agreement, but I have an NDA. So can I sign it instead of DPA? That's why we wanted to mention it and tell you what are the differences. So I'll start by saying that yes, you can, but there are certain things that you may have to follow before you do. So as I said, NDA may concern data processing, but it doesn't have to. Because DPA, so data processing agreements, is a document that is required by GDPR and concerns mainly and in most part processing of data. So it says in detail who is processing the data, for how long, and it also can define internal procedures. So if we at Woodpecker have a DPA, we would include in there what kind of people from our organization, from which departments may process your data, for what purposes. If any case the data gets leaked, what is the procedure we have to follow to inform you, how long does it take you, and so on. So everything concerning data processing is in there. So if someone says to you, I don't have a DPA, but we can sign an NDA instead of that, if an NDA has all the points that you would see in a data processing agreement, we don't see why not you cannot sign it.
Well, it's not that much about the name of the document, but what it covers. And we got the situation quite often that, for example, we as a company were about to purchase a service or a tool, and it was from South Europe, and we were asking like, hey, can we sign something concerning data safety? And we got a response that we don't have DPA, but we have NDA. And it's fine to sign it as long as it covers the scope you want. So either you should follow your own list or try to write down standards, it's up to you, but the name of document is not that much important.
Yeah.
So one more important thing about this one is we also got a question quite a few times, do you have to sign DPA? And the answer is yes. So meaning, by yes, I mean that if you are within Europe and you transfer data from one company to the other, then yes, you have to sign DPA. You have to regulate transfer of data, and basically it's simply the relationship between being data controller and data processor, and you need to regulate it. Then, of course, if it goes outside of Europe, you have to follow the same logic. So there should be always an agreement signed which regulates, but depending if the country to which you're sending is safe or not, you may need an explicit consent of the people whose data you're sending.
Yeah, and don't be afraid about lots of documents that you need to sign, or millions of people you need to contact, scan, and send your emails to. On the next slide, we'll share several tips and tricks that have helped us, and we'll give you one about managing this process. So, yeah.
This one.
Yes. So it's this one because the title of our webinar is GDPR, the 1 year in checkup. It's been almost a year since GDPR became effective, and it's been a long year for us. We are very proud that we have been ready for GDPR before it became effective, but we're in a certain position that we actually ate cake that Margaret baked on the day GDPR became effective. So yeah, but you can see that we were very proud that we were ready for it. So for this past year, we have learned our own lessons, and we're here to share several tricks that have helped us, and hopefully they will help you as well. So the first one actually concerns the position of DPO, so Data Processing Officer. And since I have ours with us, Margaret, would you take
Sure.
this one?
We heard numerous opinions like, do I have to have data protection officer in my company? And if yes, then who it's supposed to be? The very intuitive idea is that it should be probably a lawyer, because that's the person who will know the best how GDPR should be implemented. And we are not saying it is wrong, but it's not always the good choice for you. So for example, if your company cannot afford stable relation with any law office, so you don't want to employ a lawyer right now, or for example, your type of business is very complex, so you run a software company, or you run a lead agency, and the type of your business you conduct is not very obvious, then it may be worth trying to have a person inside who may help you manage data. Why? Because it's simply more natural for people in your company to come to the person they know, to say like, hey, we are buying new software, should we sign DPA or NDA or anything? Or like to be aware of all flows of data you have inside. So if you don't have a person, which may be a DPO, in the sense that you don't have a lawyer in your company, it's sometimes worth to invest in trainings, a little bit of reading, because this fact of being aware how the company works may be way much more effective and better for you. And it also may be better than having no DPO, because then all responsibility is on you or on your manager or on one person in the company, probably very busy with different things. So that's one of the tips from our end.
Yeah, right. The next thing actually concerns internal documentation and the word centralization, because we would strongly like to advise you to centralize most of the stuff. So most of the stuff I am referring to is obviously related to GDPR. So the first thing I would like to mention is the list of processors. So if your company uses different software tools, platforms, for example, CRM, for example, even our tool, Woodpecker, you need to have a list of all processors that you are using. And as I said, we advise you to keep it in one place. It is very often seen that different heads of departments have their own budgets or have their own decision-making process, and they are able to buy certain software on their own And it means that there is no place or no person within a company that knows which tools exactly are we using as of today. In Woodpecker, we keep it all in our office management, because this is a team which often gets requests to buy certain software, upgrade it, and so on. So we are mostly up to date with everything. So this list of processors, it doesn't have to be complicated, just keep it simple, because it has to be clear. And the main important thing is that you need to be able to see every tool that you're using, so every processor, then very, very detailed data about them. So our list of processors simply has name of certain company, short description of what this tool does, country that the company is located in, and information about if we have a DPA signed with them, maybe link to their terms of service or GDPR compliance subpage that gives more detailed information about how this company processes data under GDPR.
Yeah, so that's how we handle documentation. And before you have this documentation, there's always a question concerning DPA, so data processing agreement or addendum. Should I sign it? And it's difficult to answer, because it depends how much you probably need the other part of this communication, which is responsible for something you would like to purchase or for a service. But in general, we manage it this way, that I've created a list of our internal standards. So basically, something what we have in our DPA and what we consider as minimum must-have. And I keep it as a separate list, and each time we are considering signing something with anyone, we just compare with all minimum standards on our list are implemented there. If not, of course, that's a matter of negotiation, so simply contacting either legal team on the other end or anyone responsible for managing agreements, and going through why you don't have this or that. But in general, to keep it simple, we have a list, and each time we compare our list with the DPA or NDA received, and we are assuming not to sign anything what is below the standards.
Yeah, exactly. And yeah, it also helps us to choose our own sub-processors if we are thinking about using new tool or new software. This is one of the reasons that decides which one actually we will choose. It also is connected with the next tip. So as I said on the previous slide, you don't have to sign everything on paper. You don't have to send numerous emails, scan millions of documents. We ourselves use an online signing tool, and we also recommend you to do the same thing, because then you just upload one document and send a link to your clients or publish it on your website, depending on you, which way works for you best. And then you keep everything in one place. The clients have the ability to sign it whenever they can, whenever it's convenient for them. And you have all documents, again, centralized in one place. And one more thing about centralization is the access management, because it is also good to know when you have a list of all software and tools that your company uses, which people from company have access to which platforms. It's also helpful with risk assessment that Margaret mentioned before, because when you have a software that concerns very specific thing, very delicate thing, like your servers or maybe your payment processor, it's very important to know which people from company have access to it. So what harm may be done in case the password gets leaked.
So definitely you shouldn't have a situation that all company can access exactly same set of data, and that's important to remember, because in this risk assessment you should be able to prove that you take at least some basic measures to balance risks. So you should say, like, for example, I keep those data which may be slightly dangerous in the sense when it comes to leakage, but then I balanced it that, for example, I limited access or something like this. So that's just to give you the notion. Okay, so now the question, how to manage your GDPR requests at Woodpecker. Actually, we're quite excited to do something to help our customers with GDPR requests, and we came up with a small feature. It's related to unsubscribe. So basically, if you create an campaign at Woodpecker, you can add something called snippets. So it's like a name, surname, or any other type of snippet you use. In the same, or at least very similar way, you can add unsubscribe. And for the purpose of having GDPR compliant tool, we decided to do unsubscribe link in two forms. We did unsubscribe either in a classic sense, so it's very similar, like, you probably know from since cold emailing started, just you click unsubscribe and then you are either blacklisted, you just don't get any new messages from the person. But we also did something what is called GDPR unsubscribe. And how it works, it allows your prospect to choose to be encrypted, encrypted at Woodpecker. And you can also do it manually from your panel, so you can simply go to the prospect database and use the feature to encrypt from a drop-down of actions. And why it's so important? It's important because of that, we will erase data of your prospect fully. So it's not like we are covering those data somewhere in the back end, or it's just you who is not seeing the data and we can see it. If we get a request from you, so simply you clicking GDPR encrypt, we erase all personal data and we exchange those personal data for a key. But we are unable to, instead of this key, get again those personal data. The only situation when it may happen, actually two scenarios. One is that you re-upload the person purposefully, so you wish to get it re-added. But the use case we had in mind when we created it is that you get a request from a customer like, please erase all my data. And then assuming that you use Woodpecker, you can use it easily. So you just simply click GDPR encrypt and we remove data. But then after 1 month, this prospect decides, yeah, I actually need this service. So the prospect contacts you again saying like, hey, actually I would like to get in touch with you or have a call or please email me. Then we are able to take this key we are still keeping for you and reassign it to those personal data, so you get the whole sequence of emails and it's get visible. But until it's encrypted, you will see nothing but just dots in a place of this prospect usual placement, and we keep the dots just to show you the statistics in a regular manner, but we don't keep any personal data somewhere hide in the backend. And this is also why we encourage you to use Woodpecker to handle such requests, because then you don't have to remember to remove it from a CSV file and to other places, but you have it handled in one place by a simple button click. So sorry for getting so excited about it, but I really like the feature, so I hope you'll enjoy it too. Okay, so this is one part which we did. It concerns application, but of course we had to go through tons of documents, and we'll just briefly describe you what we did on our webpage. So what kind of documents you can find, and it may serve as a little inspiration for you if you are still wondering like, what should I add? Do I need additional documents to terms of service? So just to give you a notion, two first documents, safety and security, responsible, probably well known by you, for safety standards, not only personal data, but general like password, storage, and so on. We mentioned some details concerning GDPR as well, but usually we just link to other documents. In there, you can check the document if you prefer, like if you're wondering how we, I don't know, store your passwords, your credit card data, and so on. And then we have GDPR compliance, which along with GDPR statement simply describes our internal standards.
Yeah. The next document is a GDPR statement, which is actually an attachment to our data processing addendum, because we have mentioned the name data processing agreement because this is a document that can stand on its own, but it can also be named as data processing addendum, which then serves as an attachment to your terms of service, which is also referred to as service agreement. So now that we have it sorted, so GDPR statement is an attachment to our terms, our data processing addendum. And we basically did it because we didn't want our data processing addendum to be 10 or 20 pages long. We wanted to keep it simple and clear for the people who want to sign it with us. So everything concerning our responsibility And our duties, protection, and information about where to write, who to write, in case you need any information, correction, deletion of data. We included on this subpage to keep our DPA short as possible. And then we also decided to include a GDPR disclaimer in our terms of service, which of course serves as description of what your app or service does, what are the prices, because we noticed that there are different companies with different safety standards. Some companies just want to look at your terms because it's the first document that comes to mind. If they see information about GDPR and the information that we state that we are compliant, it's fine for them. Other companies have stricter security procedures, so that's why we wanted to include all those documents to say that we are proud that we are a GDPR compliant company. There's also one tip that can help you here when you're choosing your own sub-processors. Don't always believe the big green ticks on the home websites and exclamation mark GDPR compliant without looking at the documentation. Because it's very often that you can find, like I said, big green mark, we are a GDPR compliant company certified by someone. And then you look at their terms of service, securities and safety, and there's nothing. There's no information about DPA, NDA, nothing. So don't always believe what you're seeing on the website, really do your research. And we at Woodpecker have DPA as well as NDA. We don't make it public. We have it stored in our online signing tool. If you want to sign it with us, just let us know and we'll send you a link to that.
Yeah, so just as Kamila mentioned, it's up to you if you prefer to have it publicly available or you wish to send it. It's just a matter of your choice, but definitely you should have it. Okay, so this is something what we would love to touch upon in a very detailed way, but we are not necessarily able to, because when we planned this webinar like 2 months ago, we had the plan in mind that at the point when this webinar will happen, we will precisely tell you how it will be managed with Brexit. Unfortunately, we are not able to do it yet because we are still missing some basic legal agreements between, well, basically concerning Brexit. But what we can tell you right now is that most likely the UK standards of data processing will be in line with GDPR, in the sense that they simply took GDPR and enacted it as their legal act. And why I'm mentioning it, because of course if Brexit happened, that's an external country to the EU, it will at least become so. And then the question, is it a safe country? Is it a third party country? That sounds a bit odd for us because we used to think about EU with UK inside, not outside, but still, just to let you know, is that right now United Kingdom is dedicated, and it was always strongly for during creation of GDPR standards. So they will most likely follow the standards of GDPR, but it not necessarily mean that you will not need additional documents, because if UK becomes an external country, that's the same rule for all external countries, unless there is other agreement provided. So that's just to let you know, in case you're wondering. If you have any special tools, services in the UK and the Brexit will happen, that's definitely a good point there. To just, you know, check out what is the final legal decision and go back to some of those agreements. Yeah. Okay, so I think we're talking for quite a long time, so let's sum this up. Yeah, minimum for standards for cold emails.
Yes, so we wanted to prove here that you cannot, once again, send GDPR compliant cold emails without being a GDPR compliant company. So to send GDPR compliant cold emails, please mind about your own internal procedures, risk assessment, and register. And if you're sending cold emails, make sure to include a GDPR disclaimer, which also says to the person you're sending emails to, who is processing their data, for what purpose, for how long, what they can do if they don't want to receive these emails from you.
Yeah, and your company standards affect others, so that's very important to be aware that if you're, for example, acting as as previously mentioned, lead agency or simply interact with other companies, they may request you to, I don't know, help them fill up risk assessment and stuff like this. And the last one is very important to be aware that GDPR is alive. So we know that there were first cases you probably heard about if you were interested in GDPR as a topic. So usually it concerns access to data, but also the responsibilities if I'm a controller, processor, or it's a joint controlling situation. So there were some cases already and there were some penalties imposed, maybe even in your country. It depends from where you run your business. But to let you know, if you are still missing something, that's probably the right time to start managing it, because it won't be easier after 1 or 2 years to come back to all of those documentation things. So we encourage you to do it now if you're still missing this.
Yeah, and also remember it's important from business perspective as well to be a better choice for your clients, for your prospects. It's better for you from marketing and business point of view to be a GDPR compliant company.
Okay, so as promised at the beginning, we'll make a Q&A section. So just give us a few seconds to choose a question. So let's take the first. Can you link to a GDPR disclaimer on your site, or must it be in a text in the email? Well, that's a tricky question, because the rule is that it should be proportionate. And GDPR does not describe particular cases of cold emails, and there was no case law interpreting this area. But if you ask me about opinion, I would say that you cannot just write every information is under the link. You should add some kind of minimum. And in our opinion, minimum is the name of your company, and then type of processing and how to correct. So simply how to object, because objection is one of the most important rights. This is something what should be written in the email. And if I say in email, it's not just first email, but it's every email. Because it's not like if it's in a thread, it means that it applies to all. We add, for example, disclaimers in every email, but we usually do it like this. We write, hey, we are Woodpecker, we process your name and surname to send you this cold email. If you wish to unsubscribe, click here, and we have unsubscribe form. And then we add a link to our, for example, each of GDPR compliant web pages or terms of service, it depends. So this is the matter of proportionality, and we believe that this is how it should work, but it wasn't interpreted yet, so there is some still ground to consider about it.
Yeah. Is there a difference when sending cold emails to private versus commercial email addresses? What about info at blah blah blah? I might start with this one. It depends. Because the first question, it depends. If a private email has name and surname of a person, so personal data, which makes it very easy for you to find and know who this person is. Even if there is a name, for example, Anna at abc.co. If you go on the abc.co website and there is only one Anna and there is her surname included, and it's easy for you to find who she really is and find more of her personal data, there is no difference between sending emails to personal and business email. However, with emails like info, business, support, if they don't point to a specific person, there is no need for you to be able to process the data of this email address specifically.
So simply the question is if those data are personal or not. If there is name at, for example, company name. So if, for example, my email address is Margaret at Woodpecker.co, and I'm the only Margaret working at Woodpecker. And if you go to the webpage to section about, you will see me. That's very easy to track me as a person. But if that's hello at Woodpecker.co, which is used, for example, to trial accounts, that's not the personal data, so you can use it in the way you want. So all information, all emails like info, hello, I don't know, get, or not containing name and surname, or at least name, those are not personal data. So, okay, so we've got a very interesting question, and I know if you're struggling to handle this, I would love to answer. How do you handle and keep track on differences in GDPR regulation and between countries? So, for example, Germany is much stricter on B2B cold emails than other countries. And we got such questions A similar one is with Canada, where sending cold emails is way much more difficult. Maybe not difficult, but stricter law than in other countries. It depends in what position you are, because simply as for us, we are providing only a tool to send cold emails. So it's the matter of a choice of our user, how they use Woodpecker, and to use it in line is not with law of their national country, is not that much in our control, because we just provide like a service which allows you to send, but we don't control the content. So this is the situation. But when it comes, for example, to our national interpretation versus the original text of GDPR, so of course we are located in Poland, and our Polish law also imposes some particular regulation in certain areas. I just usually put it in a matrix or in a very simple Excel file, and I write like a landmark steps. So for example, is consent required when it comes to cold emails? The expiration date of data deletion, so how long you can store the data. So I try to choose those landmark elements and then compare. So for example, that GDPR unspecified up to national law, and then Germany, for example, and you put certain date, and if the consent form is required, yes or no. If yes, then in what form? And by preparing cold email campaign, let's imagine a situation that I send cold emails only to the countries where I need double opt-in list, and I need to have expiration date 1 month. I just simply track it in the sense that I name my cold email campaign, for example, I don't know, Germany / some requirement and the name which tells me something, and I just need to check it each time. So yeah, that's basically how usually I track it. I know it's manual work and it's quite a lot, but that's the only way you can keep, you know, an eye on legal differences, because that's very difficult if you have national law with strict regulation, as for example, German or Canadian one. So we have also our blog post about differences in cold email law. So we'll probably email you this one as well with our GDPR sum up from today, so you can check what we discussed there and how tips we give to our users.
Yeah.
Okay, so maybe not to keep it too long, let's try to choose one more question. Okay, maybe this about retrospective DPA.
Do I have to sign DPAs retrospectively? I contacted a lot of clients when GDPR came into force, but I forgot to do anything. Now most of these old clients are churned, and can I just delete their information? Well, we would probably advise you to yes, to do so, because as we mentioned at the beginning of the webinar while speaking about GDPR compliant cold emails, you need to have a legal basis for processing data of people you're sending emails to. So if a person is no longer your client, there is no really legal basis for you to store their data.
Yes.
Maybe if you have information about in your either DPA or on your website about the time frame that you agree to delete their data from the moment they are churned, because you don't have to do it the next day. You can wait, let's say, a month. So if it's not been a month since the moment the client has churned, you are in a procedure. So we say that, okay, it's in process. But if the month passes, there is no legal basis, so we would probably advise you to delete the data.
Yes, so simply, those are two things in here. Firstly is the DPA, so probably the relation between you and other tools you use towards those data. And then in such situation, you don't have to sign it retrospectively necessarily, but you have to request those deletions. So if you, for example, use CRM, you should request deletion from the CRM as well, if you cannot do it manually for whatever reason. But then if you have a situation that you don't have consent, then you should just simply delete it from whatever you use or whatever you store the data. Okay, guys, we are running out of time, so thank you very much for your participation. As mentioned at the beginning, if you didn't hear the answer to your question, you will still get it. We'll email you with the answer to all questions asked during webinar. Also, we'll send you some links to our materials if you're still wondering how to manage. And in case of any questions, as you probably know, you can always ask us. So thank you very much for your participation. Bye.
Thank you. See you soon.